And welcome Victoria and Colonel Ivan, also two members of our Financial Empowerment Center team. We're really grateful yesterday. Colonel Ivan had a wonderful presentation. So view these presentations on our Facebook page, which is going to be facebook.com/FECPGCC. And please like the page as well. Victoria, do you have any instructions for folks with regards to our social media?
Sure. Hi, everyone. Thank you so much for being here with us today. As Heath already said, just make sure to like and subscribe to our Facebook page. If you have any questions or anything, if you know of anyone who isn't able to join us on the Zoom, you can have them go to our live. We'll make sure to put in the chat. It's facebook.com/FECPGCC, and people can watch the stream live. And that's pretty much it. Thank you.
Awesome, great. Catrina Aquilino is a lawyer. She's a Esquire and a Prince George's County native, is the supervising attorney at Community Legal Services of Prince George's County. She provides not only mentorship to attorneys, but also actively represents clients, as well as Ms. Aquilino's career. As well. Ms. Aquilino's career demonstrates a commitment to public service to those in need in Prince George's County. She has interned and clerked for judges in the circuit court for Prince George's County, served as a Rule 16 student attorney and panel attorney for the Office of the Public Defender in the county, and interned for CLS during law school. She's also a member of the Prince George's County Bar Association and the Maryland Hispanic Bar Association, where she serves on the board of directors for both organizations. So clearly a great example to young girls, women, men, and anyone, of course, interested in legal application. And so thank you for being a great person in our community. And we know that you're honored to serve the citizens here. So take it away.
Thank you, Heath, and thank you everyone for joining us here today. And I want to express my gratitude for being invited to speak. I will be presenting on powers of attorney, and I'll also speak to clearly financial powers of attorney, but I'll also speak to the various options for medical directives, as well as give a very short discourse on wills. I do have a PowerPoint presentation, so I'm going to begin to share my screen and we can all follow along. All right, bear with me here. All right, slideshow. Okay. All right, so clearly, we're going to be talking about, as I just said, the powers of attorney, advanced medical directives, and wills in Maryland. And what I'll say that before we start, for all of these documents to be created, the agent, or the person who wants to have a power of attorney, whether it's a financial power of attorney or an advanced medical directive, which would be a healthcare power of attorney, or a last will and testament, those are going to be available to people who are over the age of 18, who are competent. That is to say that they are in their right mind to understand what the gravity of creating any of these documents entail. Okay. First, we'll talk in most in depth about financial powers of attorney in the state of Maryland. The financial powers of attorney in Maryland are based off of the Maryland General and the Limited Power of Attorney Act. It is extremely specific, the language that has to be in a financial power of attorney. So it's always good to speak with an attorney to just make sure that you're following the act and having the correct up-to-date financial power of attorney when you go to execute a document such as that. A financial power of attorney is a document that allows you to create an agent to say that I want another person to be able to act for my behalf in financial matters. We're going to talk about the different ways that that can happen, but that's the general broad brushstroke of a financial power of attorney. It is a very good idea for every adult to at least consider having a financial power of attorney. Because things are going to come up in life, and it's good to have this power of attorney as a fallback. And remember, it's a requirement of a person creating a power of attorney that you be competent. So we want to think about why we need a power of attorney now, and create the power of attorney if you want it now, prior to an emergency happening when you may not be competent to create the power of attorney. As I said, there are different types of financial powers of attorney. There's the general one, which is, as you can see, it's a wide range of powers that are granted, and that goes into effect immediately. What those ones are going to be is, that's when you create a power of attorney saying that you want your agent to be able to act on all types of financial matters that you may have. That would be anything that you can think of: doing banking, paying your bills, doing applications, things such as that. And there's no start date or end date because it's effective immediately. However, you can make limitations on the power of attorney and fit that to whatever you were trying to do, specific to your goals. You can limit, as we can see, the specific transaction or limit its scope. For example, if you want to purchase real estate and you have to go to closing, you may not be available for the closing date. You could appoint an agent through a financial power of attorney, giving that agent the specific right to act on your behalf when it comes to that particular closing, but not anything else. And that would be a very specific type of transaction. That happens a lot in business actions because of travel, and perhaps the person is not able to be available for all types of transactions. So they will use a power of attorney and do them in a limited specific transaction type of power of attorney, or limited scope rather. So that's one way of limiting a power of attorney. Another way of limiting a power of attorney is limiting the time that the power of attorney is in effect. If you do not wish to, you can have it just open, broad brushstroke, which is going to be that it's effective immediately and doesn't have an end date. But if you wish, you could have it, as we can see on our screen, effective upon disability, or a springing power of attorney. What does that mean? That is a type of power of attorney where if it states specifically that you're appointing an agent, you're appointing them for all of the powers that the power of attorney state, but you only want that agent to have that power to act in your financial matters upon your disability, when you are no longer competent to understand and make financial decisions for yourself. That would be a broad power of attorney, where you have the wide range of powers granted through one. And that is something that I believe most adults should seriously consider executing, so that they're prepared if and when a circumstance may befall them when they are unable to make financial decisions due to disability. If you do not have a financial power of attorney in place, and you become disabled such that you are unable to make those decisions on your own behalf, you become incompetent, then your loved ones will not be able to act in your financial matters without having authorization through a guardianship process of the court. That's how it works in Maryland. And so if you do not have that power of attorney and you become incapacitated, then a guardianship process is going to take a lot longer than if you have a financial power of attorney ready to go that springs upon your disability or your incapacitation. Without getting into the ins and outs of guardianship, guardianship cases can take at least a couple of months to work their way through the court system. You can try and do an emergency guardianship case, but it is not out of the realm of the norm to have to wait several months, if not more, for a guardianship case to be seen through to the end with the appointment of a guardian. So that's a very important reason why you want to think about doing a financial power of attorney, and specifically a general financial power of attorney that springs upon your incapacitation now rather than when disaster strikes. So what financial matters are covered in the financial power of attorney? So we see on our screen, we're looking at the general financial power of attorney. I alluded to some of these previously, but they're going to be what you see on your screen. So real property, like doing that real estate transaction, stocks and bonds, investing, banks and financial institutions, making sure that your checks can get deposited, making sure that an individual can withdraw money when needed for your own behalf, insurance and annuities, making sure claims are paid up on time, claims and litigation, perhaps pursuing a case on your behalf, benefits from governmental programs or civil or military service. So making sure that your if you have social security checks coming in, that those are coming in as they should be, and taking care of any problems that may arise. Retirement plans, the same thing. Taxes and digital assets. Again, the financial power of attorney allows a general financial power of attorney allows your agent to to do what needs to be done on your behalf in those areas. And you can also add special instructions if you have something specific and unique to you that you want to make sure is covered in that power of attorney. You can add that in as well. For the limited power of attorney provisions, that's going to be always fact specific, depending on your needs in that particular situation. So now let's talk about your agent. So we've talked about the fact that with the power of attorney, you're saying, I want to give the power to this one particular person to make decisions on my own behalf. What should you think about when you're deciding who you want to be the agent? The first two things: how well do I know this person, and can I trust this person? Those are extremely important factors to consider. And the reason being is, as you can tell, it is giving over a great deal of power when you would appoint someone as an agent in your power of attorney, especially if we're talking about the general broad power of attorney. You're giving it over, say it's a family member, sister, brother, a child, parent. You're saying to mom or sister, I want you to take care of my financial documents and other financial matters if something happens to me. Or if you do one that starts right away, then they would be able to act even if you're not incapacitated And you have to make sure that you trust that your agent is not going to commit fraud or somehow try and use the power of attorney to their own financial benefit to the detriment of yours. Not only does it matter about how much you can trust the person, but you also have to make sure that the person you are giving this great power to can handle the responsibility. It's not just having good intent, but also making sure that the person has the the wherewithal to excuse me, the wherewithal to carry out what is needed. And you can think about your specific circumstances, but generally that's going to be someone who can keep track of bills when they're due, when checks should be coming in, and the general things that we think of when we're talking about a financial life. And you want to pick someone who has not only the wherewithal to do that, but also the time to do that. And you have to make sure that this goes back to trust, that they will do the right thing when they're called upon. So we've talked about the agent. You can also designate an alternate agent. I think that in every power of attorney, you should have at least one alternate agent. And the reason why I say that is because when you do a power of attorney, it very likely will be needed sometime farther down the road. It may be needed relatively quickly, but there's also a chance that it might not be needed for a year or 2 or 5. And if during that time frame your agent for one reason or the other becomes unable or unwilling to act on your behalf, then you will, if you have not authorized an alternate agent, then the power of attorney will not have effect because there's no one that can carry out those duties. So it's always good to pick an alternate agent. And it's not just when we think of why a person may not be able to act as an agent later on because of death or serious injury or illness. The agent also might move away. And if you pick an agent who lives several states away versus an agent who lives in your same town, then that's going to put a lot of stress on the agent's ability to carry out their duties. So when you're thinking about an agent, not only should you think about the how much you trust the person and whether they'll be able to carry out those duties, but you should also think about naming someone who is who is closer geographically to you, so that they are more easily able to carry out the duties that come from a financial power of attorney. So you can appoint just one agent with an alternate agent, but you could also appoint co-agents. It's up to you to decide whether you want to, but if you're going to appoint co-agents, you have to make sure that those 2 individuals are going to be able to work well together and to carry out all of the duties. You don't want to pick people who are not going to be able to work together because of whatever reason that may exist. So think about your relationships and how much you know those individuals. In order to execute the power of attorney, it's not just enough to print it out and sign it and put the information in. You have to do so. You have to sign it in front of 2 adult witnesses and in front of the notary. There's a note here that the notary can be one of the witnesses, but it might be a better idea to make the 2 witnesses separate and apart from the notary to protect the power of attorney in case the law regarding notary and witnesses changes in the future. So I had to mention this in the beginning, that it's important to have an attorney help you to prepare the financial power of attorney, if at all possible, because the Maryland law is based off of the statute, as I had stated before, and that statute is very specific with the language that needs to be in the power of attorney. And if there's deviations from the power of attorney language, then that could potentially harm the effectiveness of the power of attorney, especially because financial institutions are used to the written statutes stating forth the power of attorney in a very specific manner. So it's better to go to an attorney to make sure that your power of attorney is going to correspond with what the law requires, so that you will not have so that your agent does not run into problems in the future. Also, as we just talked about the witness requirement, and the notary requirement, those may be subject to change in the future due to changes in the law. So you always want to consult with an attorney, because an attorney will know whether the law has changed, and keep your power of attorney that you create, will keep the document in a good legal order. Once you have the financial power of attorney created, what you should do is you have the original. You want to keep it in a safe place. What is a safe place? A safe place is going to be something that somewhere that if tragedy would befall you, that it will be protected. So what can that be? It can be a safe that you have in your home that's fireproof. It could be a safe in the at the bank, or any other place that would be a safe place that is also easily accessible to your agent. You want to make sure that your agent knows what to do if you become disabled or otherwise incapacitated. So your agent should know, of course, that you have appointed them as your agent. You'll want to make sure that your agent has agreed to act as your agent, of course, and then let them know what they should do if you do become disabled or otherwise incapacitated. And the reason why you want the agent to have access to the original power of attorney is because when they are trying to handle your financial affairs, many of the institutions, the banks, pension, retirement, and so on and so forth, those institutions are going to most likely want to see the original of the power of attorney and then take copies. So make sure that you have a plan that your agent knows for if tragedy happens. Okay. So those were financial powers of attorney. Now we're going to talk about advanced directives. So sometimes they're called medical powers of attorney in the state of Maryland. While clearly a financial power of attorney is very important for your financial health, a medical power of attorney is also important for your financial and your medical health as well. It makes things easier for if something happens that would put you in an incapacitated situation where you're unable to make decisions for yourself. These types of conversations and thoughts around what is required with an advanced medical directive, what decisions you have to make, can sometimes feel daunting. No one wants to think about what you want to have happen if tragedy were to strike, as far as medical care and what you do want to accept and what you don't want to accept. But it's better to think of those decisions now when you have the time, rather than waiting until until tragedy strikes. So what is an advance directive? An advance directive, as you may have already surmised, is a document where you state what you want as far as certain types of medical care. What are the types of advance directives in Maryland? Those medical directives, advanced medical directives, can center around what type of care you want with regards to life support, so life-saving care, feeding, feeding tubes, as well as whether you want to receive a pain medication to make you comfortable, as well as they can go into more of a fact specific what exact type of care you want to have. That would be more of a living will, where you specifically state the types of care that you want to have. But a simple advanced medical directive is going to touch upon the first three things that I discussed, which were whether you want to receive life-saving care, whether or not, whether you want to have feeding tubes and whatnot, and also whether you want to have access to pain medication to make you comfortable or not, in the event that you become incapacitated and are unable to make such decisions for yourself. So why should you have an advance directive in place? I touched upon that when I talked about we want to think about what we want in those situations now. So what we desire actually happens, rather than waiting until the time comes that we're not able to make those decisions for ourselves. So when you make an advanced medical directive, it is extremely similar to a financial power of attorney. You're going to appoint an agent, and the agent is going to carry out your desires. So the same analysis that you're looking at when deciding who the agent should be for your financial power of attorney, you should apply that to who you want to act as your healthcare agent with an advanced medical directive or a living will. You want to make sure that the person is trustworthy, that they will actually carry out your wishes and not their own when the time comes. You want to make sure that they are able to act as your agent, that they have the time, that they have the resources, that they can come and be available to the medical professionals if it is needed. It might be important to name an alternate agent just for the same reasons that we went over for the financial powers of attorney. You don't want to assume that your agent is always going to be available. So it's very important to consider naming an alternate agent. The residence of your agent, again, just like for the financial power of attorney, it's extremely important here. If your agent lives in California and you live in Maryland, it might be extremely hard for your agent to actually carry forth their duties under the advanced medical directive. So do keep that in mind. And the same thing with the financial powers of attorney regarding co-agents would apply here. You want to make sure that those co-agents are going to be able to work together. And especially when we're talking about advanced medical directives, which will come into place after you become unable to make your own decisions. Those are going to be extremely emotional times for whomever you appoint as your agent or co-agents. And you want to make sure that you trust, if you're appointing co-agents, that those individuals are going to be able to work together. If you think that they're not going to be able to work together, then it's probably better to just appoint one agent and an alternate agent. So with an advanced medical directive, there are specific witness requirements. The witness must be adults, so over the age of 18, and they have to be competent. The persons that you are naming as your agents cannot also be the witnesses that are signing. And at least one of the witnesses must not knowingly be entitled to any portion of your estate or knowingly be entitled to any financial benefit by reason of your death. Essentially, that whoever is acting as the witness cannot inherit from your will, or at least know that they are, and that they would not be a beneficiary of your death. That's just a protection in the code to make sure that a witness may not act nefariously later on. There are, especially with the restrictions that have come about because of the pandemic, there are ways to carry out an advanced medical directive electronically, but it's extremely the rules to make sure that that is going to have a power and effect are very narrow and have to be strictly adhered to in order to work. But otherwise, you can do it in person, socially distanced, of course. So where should you keep your advanced medical directive? You should keep it similar to the financial power of attorney in a safe place that is going to be easily accessible to your agent. But in addition to that, you want to make sure that you are placing a copy in your medical file. So you want to make sure that every treating physician that you have or other medical professional has a copy of the advanced medical directive so that they know in case something happens to you. All right. Now we'll go to wills in Maryland. This is going to be extremely, it's not going to be very detailed, but I wanted to take the time, since we're talking about financial powers of attorney and advanced medical directives, that we also talk about wills so that we can start thinking about what we might want to happen in the event that we do perish. So the will, the last will and testament. What is it? A last will and testament is a document in specific rules for signing and registering and whatnot, where you are saying who you want to receive your property upon your death. Who needs a last will and testament? Everyone should seriously consider having a last will and testament. If you have any property that you would like to leave to anyone, you should think about having a will. If you do not have a will, when you die, then you will die what is called intestate. It's a legal term which then it's basically derived from the Latin word dying without a will. And it means that your property will be distributed to your heirs as the Maryland estate rules set forth, and not necessarily in the way that you would like to be distributed. So what is property? Property for a will is going to be, and property that can be disposed in a will is going to be anything that you can think of that you have property for. So it's going to be your personal property, which might be jewelry or a nice TV. It could be a car. It could be, well, a car wouldn't be personal property, but other personal property you can think of, as well as automobiles. So your car, truck, any other motor vehicle, as well as real estate can be transferred in a will. When you do up a will, you're going to name a personal representative. A personal representative is the person who is going to handle your estate when you die. They are going to make sure that the will is carried out. They're going to start the probate process, which is the process by which the personal representative notifies the court, creates and opens an estate with the probate office, and makes sure that the rules are followed in order to properly and legally distribute the property as you so wished under the will. The factors to consider when choosing a personal representative are very much just like the factors for choosing an agent for your financial power of attorney, as well as an agent for your advanced medical directive. So I won't belabor those points here. Just as with selecting an alternate agent for financial powers of attorney and an advanced medical directives, you should consider setting forth an alternate personal representative. And again, for the same reasons, because when you create a last will and testament, it may not come into effect for a long time to come. And you want to have at least one personal representative and an alternate to ensure that, or to guard against something happening in the meantime. With a co-personal representative situation, the same problems that you think of, that I urge you to think about in considering co-agents for the powers of attorney as well as advanced medical directives would come into effect here. You want to, because with personal representatives, they have to be able to work well together with notifying your various property accounts, credit accounts, debit accounts, all of those about your death, making sure that the appropriate documents are requested and received and delivered to the court as required. And if they're unable to work together, that can cause a big problem in the process. Okay. In order to properly execute a last will and testament in Maryland, you need to have 2 adults over the age of 18 act as witnesses, and they must be attesting to the fact that you are of sound mind. That is going back to what we talked about in the beginning, which is in order to create a will, just as with the financial power of attorney and advanced medical directive, you need to be competent to understand what powers you are giving away, or what property you are designating to be inherited by what person. You have to understand what you're doing when you're creating these documents. And the witnesses should not be anyone who is named in the will. The storage of your will is going to be just as important as your financial power of attorney and advanced medical directives. It's slightly different though, in that you're clearly not going to have to give it to your medical providers unless there's an odd factual circumstance unique to you that would require that. You're most likely going to keep it in your home, keep it in a safe place, or you can even register the will with the registers of wills. It only costs $5, and you deliver it to the registers of wills office in the circuit court of Prince George's County, or wherever you may live. And that brings me to the end of my presentation. I don't know if we'll be able to accept questions and answers. I'm going to stop sharing now.
When your husband gets back.
Thank you, Catrina. Yes. So if anyone does have any questions, please, you can unmute now, or you can ask them in the chat box. Or any comments, anyone?
This is, oh, I'm sorry. Go ahead.
No, you go ahead. I'll go next. Okay, this is Susan. My question is, what is the difference between, from my understanding, wills and trusts? From my understanding, if you have a will and you have a home, if you have any debt, your whoever the will, the home is going to, the government or the state will make sure that the debts are paid. And if you don't have any money, it will come from your home. But if you have a trust, no matter what debts you have incurred prior to death, that home will still go to the person that you designate. Is that true, or am I wrong?
So my organization, we don't deal too much with trusts, so I would feel uncomfortable answering that particular question. I can say that my understanding of the main difference between a will and a trust is that clearly a will only goes into effect at the time that a person dies, but a trust will take effect when you create it. So it may have something to do with that, but it would be, that would be a question more for an individual, an attorney who deals with the creation of trusts.
Okay, thank you.
Okay, hello, this is Arnita. And now, Katrina, that was great. Thank you very much. While you was talking, I went and got I do have a will and a power of attorney and all that. And while I was looking at it, I have another question. But my first question was, I don't have any children. Well, I'm sorry, I have a son. So I have left my all my jewelry, clothes to my church, because I don't have anybody else to give it to. I know you can't tell me who to give it to, but is that that's a little out the box type of person to give it to, but is that feasible?
Well, I would not, I will say that for the question and answers period, I'm not going to give legal advice specific to any question. If you do have if after the question and answer period, you would like, we could set you up with an appointment to speak with one of the attorneys, either myself or one of the other staff attorneys, to ask to get strict advice to your particular situation. But I will say that wills.
Okay, thank you. That's fair. I'll send my my other question. While we were talking, I see my agent on my will. She has moved. So shall I get a whole nother will over? I just need to do a change of address because I see her address is wrong on our paperwork.
Okay, so I will just say that for, again, not giving a specific advice for a specific case, but for when you decide who is going to inherit under a will, it has to be a legal person, but that can be more than just a person, an individual. It could be a corporation, an entity, what have you. And as far as what happens when an individual has moved, whether it's with a will or when an agent has moved, whether with a will or financial power of attorney or advanced medical directive, that's a decision that each person is going to have to make for themselves. The person with the will or financial power of attorney or advanced medical directive. It could mean that you want to still keep the agent and you talk to the agent and they feel comfortable even living out of state, that they would be able to carry forth the duties under those particular documents. Or it might be a conversation where you want to consider doing a new will or financial power of attorney or advanced medical directive, where you appoint a new agent or personal representative. But again, if anyone has questions as to what should happen in their particular case, we can schedule an appointment to speak with an attorney. And I'll put our general email address as well as our phone call our main line, so that anyone who wants to schedule an appointment can just shoot us an email or give us a call, and we'll get you set up to speak with them about your specific facts of the case.
Good, thank you. I appreciate that information. Thank you.
Oh, you're welcome.
Hello, this is LaWade. I have a question. It may be too specific, but I'll ask anyway. When you were talking about powers of attorney, my cousin had the power of attorney, and like you said, there was no alternate. All of a sudden, he decided he didn't want to be the power of attorney anymore. And it's my mom that he was had the power of attorney for. So now he doesn't want to do it. And somebody said, well, see who the alternate. There was no alternate. Now I tried to get guardianship. This has been going on for 2 years. And I had to bring her out of Birmingham, Alabama. So it's just a big mess. The attorneys down there, you know, because of COVID, and then the judge got hit by a car, and it's been going on and on for 2 years. I just feel like I'm in limbo. I don't know what to do. And I just got off the phone just now with the insurance company. They want to know who the power of attorney, because they can't talk to me because there's no power of attorney. I'm just sitting here crying. It's just a big circle.
Okay. I could that must be a very frustrating situation. I do think that this is one where we should, I do want you to give us a call or, you know, shoot us an email so that we can set you up with an attorney to talk through like the specifics. That's certainly something that I think is more, it should be dealt with in a consultation rather than a Q&A.
Yes, thank you.
You're welcome. I do see that there's a question, what is the process for reporting financial elder abuse if it's observed? You can contact the Department of Social Services has an adult protective services unit similar to the child protective services unit, where they will investigate abuse. As far as financial elder abuse, it's always going to be fact specific, but you can contact them. I would say that would be a definite first call. In addition to the Department of Social Services, depending on whether you think it's a true emergency or not, you can contact the police. And then outside, there may be other ways to address it, but those would be the first two off the top of my head. I'll also say that for any concerns where there is elder abuse and financial elder abuse definitely happens. And frequently when that is happening, there's a negligence and potential physical abuse happening as well. If the elder is a person eligible for relief, which is to say a family member or has an intimate relationship with the person that is doing the abuse, then that might be a case where a protective order would be necessary, or maybe not necessary, but it would be an option, where a person could file a protective order on behalf of the vulnerable adult, the elderly person in this scenario, requesting that the court order that the abuser stay away for up to 1 year. So that's another option.
I have a question also. First, thank you, Attorney Guino, for the presentation. Just clear and plain spoken. That's what we really need. My question is, because all of these items will require family communication, and is there any tips or strategies you would recommend when it's time to have these discussions with families? How would you tell us to approach it? What are some tips for effectively conveying that it's time to have that conversation, or some things to consider as you have the conversation prior to a life event where you're playing catch up after that? What are some tips you'd recommend for doing that? I know every family dynamic is different, but what are some tips you'd recommend given your experience?
So I think that those types of conversations are what would be considered a crucial conversation or a difficult conversation. There are a number of books and other seminars and talks that go on as to what tools exist to deal with those types of conversations. And one thing that I think a lot of those tools have in common, or those models, depending on which one you're looking at, have in common is the idea that when you go to sit down with a person, you want to identify a mutual purpose and talk to the individual, showing them respect, but also explaining why you want to have that conversation, and explaining what your motivations are, from in broaching the subject. And that might be to say, look, I had this training, or I attended this webinar, and they talked about all of these different documents, and I was thinking about this person that you may know or that you heard about, and how it was difficult for their family members when they were incapacitated or died. Making it personal to you and your situation and the loved one with whom you are speaking. So explaining, having a mutual purpose, which is going to be having everything as much as you can prepared for if and when a person either dies or becomes incapacitated. So having that mutual purpose, explaining why you want to have that conversation in as a non-threatening a way as possible, but making it personal to you, and then going forth and trying to just have that conversation. Obviously, though, in having that conversation, it's always going to be colored by the relationship that you may have with the loved one, and you'll know more what ways are best to broach those subjects, and what ways may not be helpful. But those would be my first suggestions off the top of my head.
Thank you. I have one follow-up question. Could you just talk about the cost of probate versus you have a will in place and it has to go through the court system and you've got to go through the probate process versus no will? There's still a cost because it's going to be probated, but the state's going to do it. Can you talk about is there a cost difference given the two directions it could go?
I would say that the bulk of the cost difference is going to be if you die, when a person dies intestate, then things may I'm gonna back up. So the benefit of having the will done up when a person is competent, especially if it's registered with the Register of Wills, it takes out the doubt. You have the will, it's done. Nobody's doubting the authenticity. It may be doubted, but the hope is that it will be less doubted. That the document, the will be less questioned than especially if you file it with the Register of Wills, than if it was kept at home, or if you didn't do the will at all. So if you remove as much doubt as possible from the probate process, it's going to streamline the process. And if you streamline the process, that means that whether you need to have an attorney, it may be that you don't need an attorney, especially if we're talking about a small estate. And then if you don't need an attorney, you can save yourself a lot of money, or the personal representative will save themselves a lot of money. And that's where the bulk of the cost comes from, which is the hourly rate of the attorney that's representing either the personal representative or someone else that wants to come into the case. So removing the doubt is the biggest benefit in creating a will. When a will has not been created, yes, there are intestacy laws that govern what should happen and when it should happen, but doubt comes into play. For example, there are cases where, so intestacy laws, without going into the ins and outs of how it can be, is that your family is going to inherit upon your death. So your children, your spouse, maybe your parents if you don't have the children or spouse, your brothers, sisters if your parents have predeceased you, and so on and so forth. There have been cases where a person dies without a will, and an unknown child comes into play. That could throw a lot of doubt and a lot of time into the proceedings, which only serves to complicate matters. And if a matter is complicated, it might require an attorney to get in or spend a lot more time, and that's going to be a lot of money. So that's just one example where having a will would have created a lot less doubt, because either the unidentified child would be in the will or not in the will. So it would have removed that particular doubt. So I would say that that's one of the biggest benefits of the cost savings behind having a will versus not having a will.
Okay, thank you for breaking that question down. Thank you so much.
You're welcome. Thank you for the question.
Are there any other questions or comments?
Oh, I was typing it. Hi, how far back can you go back and review a registered will? I need to check a will back in Alaska.
Where? Alaska?
The state of Alaska. My aunt's will was registered, but that was like over 10 years ago.
Each state is going to be different, and I'm not barred in Alaska, but I would say the first thing I would do is probably Google it. The Register of Wills office in Alaska, and then hopefully they'll have a website that'll give that information. And if not, they'll have hopefully a phone number where you can call and see. I would imagine though that a will that was registered 10 years ago should still have it, barring any occurrence where there was like a flood or a fire or something that destroyed it. Hopefully that should still exist though.
It might have been more than 10, but it's less than 20 years.
Even so, if something happened within, of course, every state is different, but I can say I've known of cases where, like a case from, it's not a probate case, but a family law case from 60 years ago, where Washington, D.C. still had the case file, just to say like how far back certain jurisdictions may have documents. So I think that hopefully that will should still be in place. It's just contacting the Register of Wills office.
Thank you.
So as far as I don't have the data on guardian cases. As far as when somebody doesn't have a will and they die, then an estate needs to be opened, and it's going to go under the rules of intestacy. As far as how many cases are processed through the intestacy rules versus a will, I don't have the data on, unfortunately. But it's all, I would just encourage people to really consider having a will, just because it removes a lot of well, clearly the doubt that I talked about before, but it also, I think, helps your loved ones after you pass to just have those decisions already done. So there's a framework of what needs to happen instead of not knowing what's going to happen, or the fights that the emotional problems that might come from the interpersonal issues of just when somebody dies, and how we as humans process emotions. So having a will is just one way of trying to make a very hard process a little bit less hard.
Another quick question. If a will goes through and it's uncontested, it's uncomplicated, so kind of pretty straightforward, what is a pretty much processing time for probate? What type of time do you expect before the probate has been administered, and now the process is complete? What type of average time are we talking about, at least in Maryland and the area?
I'm not sure. It will depend on the size of the estate as well as just, and with the COVID in place, I think everything kind of screamed to a screeching halt. So unfortunately, I can't give you an average time, but it's certainly going to be much less time than if there's a contested.
How about prior to COVID? What did you see in terms of prior to COVID for if a will's process? I understand what you're saying. The size of the state may make it more complicated and extend the processing time.
Well, it's just I mean, I just don't feel comfortable saying how long, because it depends on a lot of factors. I can't just say how long for wills cases in general.
Sure. Thank you.
So as far as when the laws change, I am not aware of any changes to the laws that weren't included that would be coming into effect in October. But normally, the way the laws get changed is that after the General Assembly session, which normally gets over on April 15th, although it was a little bit earlier this year. Normally, the new laws will go into effect on October 1st. Sometimes that gets pushed up to start on July 1st, but normally it's going to be October 1st that the new laws go into effect.
Okay, thank you. Because I noticed in your document that you had referenced May 2020, and so I was wondering if that's something that typically change, or have you seen any of these laws change over the last few years as it relates to maybe the witnesses or other things that are related to the wills or the other two documents?
So like I said, there's no changes that I'm aware of as far as relative to what's in the PowerPoint presentation. But as far as the way the laws have changed over the past, say, 10 years, I will say that the biggest changes, especially recently, not within the past couple of years, but the biggest recent change would have been the statutory language for powers of attorney and advanced medical directive. Several years ago now, I don't recall it off the top of my head, but it used to be that the financial powers of attorney specifically didn't have a statutory language, so it was all over the place with attorneys using different types of languages based off of getting a form and using that and it being different with different offices. So that was probably the biggest change, and then the signatures, I think, is going to be the other biggest change that to look out for, barring something something unusual happening that I'm not thinking of. I think the biggest changes that will be coming would be to perhaps require different witness requirements or notarization requirements. That, and also what makes a large estate versus a small estate. I believe that the difference is 50. A small estate in Maryland is 50,000 or less, but that number changes every so often, just to keep up with inflation.
Right. I think, yeah, that could be true, because I believe in DC it's like 40,000 for a large and 10 for a small. But that's in DC. Okay.
Yes, and I just looked it up. It is 50,000 or less. But for example, that people who died before October 1st, 2012, it was 30,000 or less. So those do get updated from time to time. It's not every year by any means, but it is something just to be aware of.
Okay, thank you so much. Are there any other questions?
Oh, can we get a copy of the PowerPoint? Just so I can refresh.
I'm gonna let Miss Katrina answer that, especially from a legal standpoint. I'm not so sure, but Miss Katrina.
That's fine. We can give you that the PowerPoint. We'll send it out as a PDF.
Thank
I just need the information as far as where to send it.
Thank you.
Okay, well, thank you so much, Katrina, for sharing the information with us today. You provided us with a wealth of information that we can definitely use, and we also appreciate you entering your telephone number or email address into the chat for people who do want to sign up for some one-on-one counseling. If you have any other announcements about community legal services that you would like to share with us, you can please do that at this time or put it in the chat, and then we can make sure that we reach out to you or join you on some of the other great programming that you do there. And so thank you so much again for spending this time with us and sharing this very valuable information.
Oh, and thank you once again for inviting me. Anytime that we can, we like to give presentations to the community just to make the process a little bit less scary, especially now with coronavirus and all the restrictions and things that have been born from that. We are community legal services. We have still been, apologize for that. We have been working remotely. Our clinics are normally in person. The vast majority are, but we have moved all of them to remote. And so any questions that you may have on landlord tenant issues, estate planning, family law, guardianships, foreclosure, bankruptcy, general civil, domestic violence, questions like that, you can always give us a call. We do have some webinars through Facebook Live that we put on every Tuesdays. We have Tenant Tuesdays at 1 o'clock. And we will be launching this coming Monday, August 17th, a Spanish language legal webinar series that'll be on Mondays at 6. So anyone that wants to check those out, you can just find us on Facebook. I'll put that information in the chat.
Well, thank you so much. Colonel Ivan, do you have any last thoughts before Ms. Katrina leaves us for today?
I think it's great that we have this kind of outreach and get this information, because this gives folks an opportunity to be proactive. And I'm sure she has seen families trying to play catch up when no will was in place, how much more complicated it was, and maybe more expensive it was, and much more stressful trying to figure things out versus when folks tried to figure some things out and put together a plan and the directives she referenced. So there was a roadmap. And most folks, I think, avoided. I remember reading a statistic that more than 50% of the people who died in 9/11 did not have wills. And typically, most folks don't have wills. So, you know, it's really unusual when people step out to do that, but it's really out of love and concern for your family that you're doing that, because you are taking some of the stress and some of the complications out of their lives by thinking and planning ahead. It may be a difficult subject to discuss, but it doesn't have to be. It doesn't have to be morbid. I think you have to, how am I going to bring about some order, get some help? And how can I help my family? Because we come in this world, we're going to go out this world and have a plan. And I think just her giving us some tools and some insight and information helps the process and helps us, give us some confidence that we can do this. And we should do it. And I know another thing I was concerned about, because that also, without a will in place, leaves you vulnerable to the state. Again, you're on their schedule now, versus maybe it'd been maybe a little less complicated, as you said, if you had clear plans and take the doubt out of it. that's the only comment. I'm just glad she's here to give us some great information.
That's right. Thank you so much. Thank you. Victoria, do you have any other parting words for us before we end the Facebook Live? And for people that tuned in on Facebook or who will tune in later, we thank you so much for joining us, and we look forward to you attending our future programming.
Yes, thank you so much again. Thank you, Catrina. Thank you, Plachette and Colonel Ivan. Everyone, I just want to give you some last announcements. Again, thank you so much for joining us. If you joined us all week, thank you. I hope you learned some things and got some good information. Just wanted to inform you all that next week we will be having virtual empowerment hour again, and we're focusing on the financial genius and college students. So if you have any college age students or know anyone or are a college student yourself, please come back and join us. Same time, 1:30 p.m. to 3 p.m. We'll be sending out the link and information on that as well. But please come back and join us for that. Also, if you're interested in any of our free financial services and you haven't taken part of them, please visit our website at www.pgcc.edu/go/FEC. We'll also put that in the chat where you can look at our upcoming workshops and also to sign up for coaching or tax preparation as well. And if there aren't any other questions, those are all my announcements for right now. Thank you so much, everyone.
Yes, thank you so much, Victoria. So we will end the Facebook Live now. And as we are ending it, thank you all. We're going to give you a virtual hand clap for each of you taking the time to join in today and to learn about the wonderful things that are taking place at the Financial Empowerment Center and as well as at Community Legal Services.
And thank you for inviting us once again.
Okay, well, thank you so much. Well, each of you have a great day, and we look forward to seeing you tomorrow.
Okay. Everybody, bye-bye. Be safe.
Bye.
Thank
you.
you.
Thank you so much.